I'm glad to see so many people here, and thank you for coming. And as usual, you know that we video these workshops, and we'll be posting the video on the internet in the next several months and sending you all DVDs. Today, in our annual maintenance workshop, we're going to talk a little bit about what happens if we become incapacitated. And really, this is a great workshop for you to share with your family or those that will follow you who are named as your powers of attorney or who are named as your successor trustee. Because what we're going to try to review today a little bit is what exactly happens and what steps should be taken at that point. And how, for example, your loved ones can call us because we drafted your documents and help them through that process. So does that sound good? All right. So today's discussion is really about you. When I say grantor, this is focused on the grantor's lifetime. What am I saying there? You know, you're the grantor. If you have a trust, you have a will, you have a power of attorney, you're the grantor. You're the person who granted the power to somebody, to yourself first as trustee and such, and then to somebody else to act as your power of attorney. So today's discussion is really about during your lifetime, not at your death. That's a whole separate issue. That's trust administration and so forth. But what we're talking about is if you should become incapacitated, you should become to the point where you are no longer capable of handling your own affairs financially and maybe even health care-wise. Now, sometimes there is a short period of time where we're incapacitated. Sometimes we're not incapacitated at all. And sometimes there's a very long period of time. You know, that's for those of us who are unfortunate enough to develop dementia or Alzheimer's. We might have a long period of time where we are incapacitated and someone else might be doing things for us. So today's discussion is focused on the roles of those that you've named to assist you. So when we get these calls, you know, what should the family do first? Here's what typically happens. I'll get a call from son, let's say. There's something wrong with mom. There's something wrong with dad. We're not sure that they're capable of handling their affairs anymore. They're not opening up their mail. They're not paying their bills. You know, things of that nature. So what should they do first? Well, the first thing to do, call us to tell us that that's what's happening. They suspect there's a problem. Now, a lot of you might be worried. You know, we're the grantor. We're the person granting those that follow us these powers. We're oftentimes worried that they're going to pull the plug, not pull the plug, really, this isn't health, this is more financial. They're going to try to change the trustee or change the power of attorney quickly, too quickly. But my experience is, I think Mike will say the same, our experience is that, if anything, our families usually take too long. They don't want to upset mom or dad. They're afraid that mom or dad will get upset with their suggestion that they shouldn't be doing these things anymore, taking care of their own financial affairs. So if there's a problem, the first thing they should do is talk to us. And what we usually say is, do you have a doctor's opinion? Has mom or dad been diagnosed with any kind of physical or mental condition that would suggest that they shouldn't be handling their affairs any longer? And if the answer to that is no, a lot of times what we'll say is, well, can you take mom or dad to the neurologist? Now, oftentimes your kids or whoever's named doesn't live here with you. So if you get a call from them or from me about that, that can be rather upsetting, can't it? But remember, you know, the ones that you've named in your documents are the ones that you trust, right? You wouldn't name your son to be your power of attorney or your daughter to be your successor trustee if you didn't trust them, right? Okay. Boy, everybody's groggy this morning, aren't we? So if they're expressing this concern, please give them the benefit of the doubt. And if if it's something that should be done, why don't you go see the doctor? And if you're okay, you're okay. But now if we get the neurologist report, what happens? Let's say the neurologist says there's a problem. What do we need in our office to help your kids? Well, remember that you all filled out those organizers for us when we did the estate planning? Do you guys remember doing all that? And you all hated it, didn't you? Right? Yeah. And remember when you sat and you did your planning, most of you actually changed, we signed documents changing assets into your trust, right? And part of maintenance program, by the way, is if you have new accounts and you haven't told us about it, make sure you do. Because one thing we want to look at is we want to make sure that it's in your trust properly. And the other thing we want to make sure if it's not, we're going to put it in your trust, right? If it's an asset that should be in your trust. But the good news about all that trouble you went through to help us with that, is when your kids call us or whoever's your successor trustee calls us and says there's a problem, what do I do? Where are the assets? We should know as long as your file's up to date. As long as you've told us, hey, we opened up this new account since I last saw you. So what we'll ask the kids to do is please gather any information that we don't know about. So let's go to this next issue about how we determine your incapacity, and I'll turn it over to Mike Hill.
All right. Good morning, everybody. Based on what Craig said, so far it's just the background. What are we looking to do if we become incapacitated? And so now what we want to look at is how do we actually determine that? Craig talked about getting the neurologist opinion, something may be going on, but there's actual provisions in the trust that speak to this. And so typically what it all centers around is if we're unable to handle our affairs. If something's going on and something, we're missing something. And so it's the legal, the tax, the financial decisions, they start to become more difficult. Craig mentioned not opening the mail, not paying the bills on time. All these things are items that the kids can look at to see, well, something might be missing. And like I said, there is a provision in the trust that speaks to this. And here it is. This is in everybody's Article 4, Section 4.01, definition of a settler's incapacity. Settler, Craig mentioned the word grantor. Settler is interchangeable. The settler is you. So a settler will be considered incapacitated during any time when the settler, you, and here's the key, are unable to effectively manage your finances, your property or financial affairs, whether that's due to age, illness, mental disorder, medicine, or any other cause. So it's not because we're getting older, obviously. It's not because we're on prescription medication, but it's because of these things we're unable to effectively manage our property or financial affairs. Now, that's a pretty broad definition, but yeah, and go back to the last slide. So the next kind of logical question is, who decides that for us? When do we meet that definition? When are we no longer able to manage our own affairs? And again, the trust speaks to this, and we've got a couple different options. First off, if we see it, if you see it in yourself, you could simply resign. And we've got a lot of clients, seems every year, they either get tired of dealing with it or start to see something might begin, some symptoms are beginning, so they resign and let the kids take over or the next in line take over. Usually when we're getting the call, it's the last one here, the disability panel. And again, back in Article 4, right after that definition of incapacity is where we name our disability panel. And our disability panel are the people that we love, the people, back to what Craig said, the people that we trust to make this call for us. And the disability panel is the one that says, yes, mom or dad or brother or sister or whoever it is does meet this definition. We're trusting them to see it in us and say, yes, we are incapacitated, and it's time for our next in line trustee to take over. Okay, so we've got the definition in the trust, and then we've got the mechanism in the trust. Now, for most people, it's the spouse first. Usually it's each other, and then a majority of the kids or a handful of the kids or whoever you've selected with us. And it's right there in Article 4 as to the people that you've named. Now, as far as our process, what happens when we get that call? we've got to be a little bit careful, don't we? You know, if Joe Blow calls us and said, hey, mom's incapacitated, whip us up one of these disability panel documents and let's remove her, you know, we need to make sure that we can actually talk to that person. And so the first thing that we'll do is we need to ensure that we have the ability to communicate with this person. Remember, attorney-client privilege, we got to be careful. And what Craig mentioned earlier, filling out the organizer, when you first sat down with us in that first meeting, one of the last pages that we probably talked about was our release of confidentiality, where we say, hey, attorney-client privilege, we got to be careful if someone were to call us up. Hey, who do you want us to be able to talk to no matter what? So if your child calls us and says something's going on or I need something, do I have the authority to talk to them without getting your permission first? And it's right there in the service agreement, one of the first things that you sign with us, and that's where you said, yes, I want my oldest child or I want all my children to be able to talk to you. So what will happen when a client or when a child calls, that's
even you know, who's named as your trustee?
Yeah, your successor trustee, your power of attorney, all these individuals. So when a child calls, that's one of the first places that we go to see if we can actually talk to that person. And if they're on the list, we talk to them, and we'll discuss that in a minute. If they're not on the list, if you didn't give us authorization to talk, we don't say, hey, there's a list and you're not on it. But typically we'll say, sorry, I can't talk to you, attorney-client privilege. Let us talk to the doctor or to the nurses and find out a little bit more. Or is your brother or somebody else around that we can talk to? So we do discuss those concerns with the family members or with the caller. Like Craig mentioned, we do need to review our file to make sure that we've got as much financial information. Some of that may have changed over time. And again, like Craig mentioned, the maintenance program, we need to make sure that everything stays properly funded. But then we work with whoever you've named in your disability panel or whoever has that authority and your financial advisors to start the transition, to start everything moving over to the name of the new trustee. And so that's and we'll talk more about that as we go along. So Craig's going to start talking about these different roles and powers of attorney versus trustee and those types of things.
Thank you.
Okay.
So just to kind of build on what Mike just said, whoever is named in your documents as your next successor trustee, as your next power of attorney, in your confidentiality release to us, that's one of the options. You know, you initial and says anyone who's named as my next power of attorney. So whether, or as your trustee. So if it's your son or daughter, whoever it is, you don't have to worry, you don't have to call us, you don't have to say, hey, I want to make sure they're on the confidentiality list. Chances are they're covered one way or the other. Okay? If they're named as a successor trustee or a power of attorney for you. So what are the major roles that we're going to talk about today? You know, when we have a company, companies have what? They have presidents and vice presidents and secretaries and treasurers, right? And sometimes in those companies, it's one person doing all those roles, right? You might, you know, a small company might be the same guy being the president, vice president, and treasurer. Kind of the same thing here. We have different roles in your documents. Now, it could be different people serving those roles. It might be the same people serving those roles. But let's talk about what those roles are. The first role is the power of attorney, your agent under your power of attorney. Sometimes you hear this person called your attorney in fact under power of attorney. Does that mean, is that referencing me or is that referencing Mike? No. Your attorney in fact is the agent that you've named under your power of attorney. But I'm going to refer to them as your agent today. Your trustee of your trust. In rare instances, there's guardianships, and we'll talk briefly about guardianships at the very end. And then, of course, there's your surrogate under your healthcare proxies and your living wills. So those are the various offices that you have in your documents, and they may or may not contain the same individuals serving in all those roles. Now, when they're acting for you and you're incapacitated, if they are a beneficiary, does that mean they can take money, you know, their 1/4 share out right now? What do you think? No, that's right. They are not yet beneficiaries because you haven't passed away. Okay? So they are your agent, they are your trustee. They are something called a fiduciary. They have a duty to you to act in your best interests. So it doesn't matter if they are a beneficiary or someone else, their brother, sister, their child, someone's a beneficiary. That doesn't really matter, because what they should be doing while you're still alive, but they're serving in a role for you, is acting in your best interests. That's their job. And they should act as you would have acted. In other words, they should try to do what you would have done. Now, it's hard to understand exactly what your mom or dad or what your sister or brother or whoever, it's kind of hard to foresee what the person would do, but what their job is to do the best they can at mimicking what you would have done in the same situation.
First up, power of attorney. As most of you may recall, the power of attorney statute changed, completely redrafted, completely redone back last October 2011. And we actually did a workshop here in this very room back in February, I suppose. If you haven't gotten our Power of Attorney DVD, we do have those. We got a handful here. It's linked on our website. So that's a good one to kind of bring you up to speed with the changes in what exactly happened and why the powers of attorney needed to be changed. But like Craig mentioned, the attorney in fact, the agent, is the person who is actually signing and who's actually conducting business on your behalf. Now, one of the changes in the power of attorney law is they are all now effective immediately. And now, if you have it signed, it's effective immediately. However, they need the original, and they need to go through the hoops that we're getting ready to talk about in order to actually use it. Now, when we have a trust, and everybody here has revocable living trust with your assets funded into it, one of the questions that we get a lot is, well, hey, if we're doing our job right, if we're getting everything funded into our trust, why do we need a power of attorney? Because the trustee takes control of the trust assets. We don't really own anything that would be subject to the power of attorney. Because that's true. The power of attorney does not govern the revocable trust assets. Very big distinction. Any asset that's owned by the trustee's in charge of. We'll talk about them next. Any asset still in your individual name is what the power of attorney is going to control. But for most people with certain assets, not everything actually goes into the trust. A lot of assets name their own beneficiaries, right? The big three are life insurance, 401ks, retirement accounts, and annuities. Those are the big three assets that still name their own beneficiary, and we don't actually transfer to the trust 9 times out of 10. And so the power of attorney speaks to these assets. The power of attorney, the agent under the power of attorney is going to be the one that takes out your minimum required distribution. Takes out more than the minimum required distribution if you needed to. But if we're concerned about income tax planning, the power of attorney can make charitable donate. I mean, there's any number of things that the power of attorney is going to be in control over, and it's very, very important. Even when we have a trust, even when all of our probate assets are transferred to the trust, we still have these big three assets that are going to be individual, and the power of attorney is going to have a lot of power over those. And then the last thing is the ability to contract. It also covers pretty much everything else that you can do, such as open a new credit card or contract. I had a client just last week, Shell Point called me. They have a prospective Shell Point resident that the son, as the mom's power of attorney, is contracting and negotiating with Shell Point to get her in. Mom can't really do it, so the son's actually doing that under the power of attorney. So power of attorney, very, very important role, really to avoid guardianship as well. Craig's going to talk a little bit about guardianship in a little bit, but it's kind of our last-ditch effort to make sure it keeps us out of any type of guardianship court. So what do we need to do in order for your child or your loved one or whoever, your agent, to use the power of attorney? Well, first thing we'll typically do is once we get that call, and like I said earlier, once we get permission and authority and make sure that we can talk to them, one of the first things we need to do is record the original. Most of the institutions that we deal with, most of your banks and your brokerage firms, they're going to need an original, and there's only one original. And so typically what we'll do is we'll record it with the clerk up at the courthouse and then get certified copies, which are certified to be just as good as the original. They're basically additional originals. And we'll pass those out to the various institutions. Very, very important that they get the proper documentation that it's time for somebody else to take over. Again, there's some red tape that usually will happen with the brokerage. There'll be some forms that the banks or the brokerage houses make us fill out. I always joke with clients that kind of the golden rule applies when we're dealing with these banks. And the golden rule is he who owns the gold makes the rules. And so the banks have all their different forms and all their different paperwork that we've got to fill out. But an important distinction, though, is when the agent takes over these accounts or these assets, they're not a co-owner. It is not their money. Just like what Craig mentioned a minute ago, they're not taking it for themselves. They still have a fiduciary duty to you. They've got to make sure that they don't upset your estate plan and that we don't mess anything up. So they take over as your agent, not as your co-owner. And we've got another video that most of you, I think, should have, the perils of joint accounts and what will happen if that were to happen, some of the disadvantages and why we never want that to be the case. So that's on our website as well, and we've got a bunch out there. So the agent's not the co-owner. They're just in control of things and handling things for you. Now, typically, the agent is generally the same person as the successor trustee. So one of the things that we want to do is, under the power of attorney, we can actually fund the trust. So let's say there was some bank account out there that we didn't know about or that was still in your individual name. You became incapacitated, and the agent took over and started paying the bills and handling that account. One of the first things that they really ought to do at that point is go ahead and fund that particular account into the trust at that point. Maybe you didn't do it while you were alive or while you were competent because it was your revolving checking account, and it would have required a new account number or changing your automatic deposits and automatic withdrawals, or it would have been a lot of hassle. But when the power of attorney takes over and the agent comes onto that account, they're going to have to jump through all those hoops anyway, change over everything. So we'll typically go ahead and transfer that to the trust at that point. And the power to fund your trust is right there in the power of attorney to make sure that they can do that for us. So the next role is the successor trustee. And remember, the successor trustee is the one who manages the trust assets. And again, doing everything with our funding process, this should be the bulk of your assets. Outside of those big three that we talked about. Your standard brokerage accounts, your real estate, your checking and cash accounts. The successor trustee is going to be in charge of those trust assets. And this is in Article 3 of your trust where we name who our successor trustee is. We do have two different types of trustees, and what we're talking about here is our disability trustee, our trustee upon our incapacity. We also name in the trust a death trustee, a trustee who takes over after we die. Usually they're the same people, but sometimes they're different. Sometimes I want my daughter to be my disability trustee because maybe she's local and she can be here to help, but I want my son to be my death trustee because he deals with the family better or can pay the bills and do all the things that need to happen after we pass away. We're talking about here the incapacity trustee, the disability trustee, the one who is stepping into your shoes and taking care of your finances for you while you're still alive. Now, how do we do that? I mentioned this a little bit earlier. We could have you, one, resign. Okay, we could resign and let the next in line take over. Or we could actually have you removed by the disability panel, and that's when we go and get the transitional events, the document that we call it, and they'll sign off saying that, yes, we meet this definition of incapacity and it's time for the next in line to take over. So after we get the person removed, the successor trustee has to accept. And there's a document that they sign that basically says, yes, I'm willing to serve as successor trustee, and I'm willing to take on the roles and responsibilities that's going to take into consideration. And that's a very, very important step, though, because maybe I have 4 kids, and maybe I name them 1, 2, 3, 4. Well, what if my top choice is going through some hardship, or is busy with his family, or is in the middle of a business deal or something and doesn't really have the time or the ability to do it? And the next in line might be the most appropriate choice. Well, the first one that I named might say, you know what, we're going to let the second one take over. Well, the second one is going to be the one that signs the acceptance. They're going to be the one that says, yep, I'm going to be the one to take over and accept these responsibilities. Okay, and after they accept, whoever that next in line trustee is, they're going to, again, work with us and the brokerage accounts, the brokerage firms to retitle the accounts. While it's you, it's going to be John F. Client, trustee for the John F. Client Trust. So John Doe, trustee of the John Doe Trust. And then once they take over, it's going to be John Doe Jr., trustee of the John Doe Trust. So it's going to be son, trustee of the Dad's Trust, or whatever it is. So that's another important distinction, because the banks need to know who's the current serving trustee. So we show them the transitional document, we show them the necessary pages of the trust, we jump through whatever hoops that they require, and we get the new trustee named as the trustee on all of the accounts. Now again, just like with the power of attorney, the successor trustee, the new trustee, they are not the owner of the accounts. The trust is still the owner of the accounts. They're the fiduciary. They're the ones that are in charge of it. They're the ones that are in charge of paying the bills, doing the investments, working with your advisors to make sure that what you would have wanted is carried out. The successor trustee can actually, let's go back to my example. If I have 4 kids and my oldest is still really the best choice, but they might be a little too busy to pick up everything and come down here, what they can do is they can actually bring on help. In pretty much everybody's trust, we include a provision called a silent partner trustee. And what the silent partner trustee says is, if I'm named as an individual trustee in my mom's or in somebody's trust, and it's a little bit too much for me, but I don't want to resign and let the next person take over, I can hire somebody. I can bring somebody on as my equal to serve as my co-trustee. A lot of times it's that next in line. It's that sibling where they get to do it together. But if it's a little too much, if we need some help, sometimes it's a professional trustee. If the investments are pretty, not extravagant, but if they're sophisticated and they might not be the best person to handle the investments, they could bring on a professional trustee to serve as co-trustee with them. All those provisions are built right into the trust to really give the kids as much flexibility and as they need to really help you and step in and fill your shoes. Now, they also have, like I mentioned a couple times, the duties and responsibilities. They have the full duty and responsibility that you would have. So that includes filing tax returns. I mentioned earlier the taking the minimum required distributions out, making sure withholdings are proper. Pretty much do everything that you have, that you have to do. But all of that stays the same while you're still alive. So they'll file your tax return for you. It'll still be a 1040. Your 1040A or EZ or whatever it is. They can work with your same CPA to make sure that all that still goes along just the way it always has. That's still why you're alive. Different story after you've passed, but while you're alive, none of those issues should change.
All right. So a lot of information, right? We always do that to you, don't we? You notice I have Mike always talk about the hard stuff. I take the easy stuff. Yeah. So let me boil it down now. What happens, how we help, what's the protocol when your kids call? Or even when a trust company calls that's acting for you, or some other person or relative who's acting for you as your power of attorney or trustee. So the first thing we do is we discuss the way that the transition of authority occurs. Remember back to neurologist reports or anything like that. We make sure that it should happen, and then we help them make it happen. Then we prepare or oversee the documents to effectuate the transition of authority. That's naming John Jr. as trustee for John's trust. So we'll help with that paperwork. Your kids don't have to do it all. We have a team that will help with that, with all the documentation. So it makes it kind of easy on your kids or whoever's next acting. Next up is we'll coordinate with your brokers or with your CPAs or your tax return preparers. Then we'll describe the duties. Remember, Mike has been hitting a lot on what are your duties when you're acting as your your parent's trustee, or you're acting as your parent's power of attorney. What is it that you should be doing? What are your responsibilities? And do you kind of get the sense now of how big of a job it is? You know, you all have heard me say several times, if you've sat in any of these workshops that we've done, you know, I always say things like, you know, well, let's go back up. You know, when we ask you who your successor trustee should be, a lot of you say, well, my oldest son. Well, why? Because he'll be upset if he isn't named. How many have told me that? Or Mike, right? He'll be upset. Well, tell me about your oldest son. Well, he's been through 3 divorces, 2 bankruptcies, you know. So you can see from today's discussion, can't you, that it's a huge responsibility. They have a lot on their shoulders when they're named. So you want to make sure you've named the right parties. Now, I'm sure all of you have, because we've been through those discussions with you. I'm really doing that talk for the benefit of those who might be watching the video and haven't visited with us before. And then finally, we'll answer any legal questions that arise. They always do. Now, one of the responsibilities that we talked about, and we haven't really talked about yet, are accountings. You know, you don't account for your income and expenses and what you did with the money that you spent, right, on your trust, because it's yours, right? One of the things that we do suggest when one of your kids takes over, for example, as trustee, and a professional trustee will always do this, you know, bank or trust company will always do this, but we do suggest this to your children when they're acting as trustee, is that they actually prepare an accounting, work with their accountant to document from the time that they take over what they're doing. The income that's earned, the expenses that are paid, the distributions that are paid, and all those sorts of things. Why do you think we tell them to do that? Anybody have a guess? What? What do you think?
They're held accountable.
Well, they're held accountable, but to whom? That's right, the siblings. Someone said the siblings. You know, a lot of families, everybody gets along just fine, right? Sometimes, what happens? You know, what we're honestly worried about is, you know, you pass away, and now the child who was your trustee or your power of attorney, they're administering the estate, and we send out an inventory to all the beneficiaries, and they say, I thought there was twice that in the account. What happened to it? You must have stolen it when you were acting as power of attorney. That happens sometimes. Not often, doesn't happen a lot. Sometimes it happens. So we suggest to your child who is serving in that role to have an accounting, to make sure, or at least to prepare accountings, so that if that question ever arises, we have documentation as to what transpired. Now let me talk for just a moment about guardianships. In the documents that we prepared for you, there's something called a pre-need guardian. Do you guys remember that? No? You mean when we were throwing all those papers at you and you were signing, you didn't remember that? Come on. All right. A guardianship is really, really rare when you have a trust and a power of attorney. And the reason it's rare is because it's a very, very serious procedure. When you're adjudicated incapacity, this is an adjudication. This is a court adjudication of your incapacity, meaning that you legally can't sign your name to do anything. You can't sign your name to vote. You can't sign your name to a contract. You can't sign your name to a marriage license. Now, do you know why sometimes we have to do a guardianship even when you have a trust and a power of attorney? We actually had this happen not too long ago in my office. Son took over for Dad. Someone who I would label a gold digger latched on to Dad. Dad was going to try to transfer his house and IRA accounts to this person and marry her. And what happens when we marry somebody without a nuptial agreement? They have all sorts of legal rights, don't they? So children came to us and said, what do we do? Because even though you might have dementia, you might have Alzheimer's, when we remove you as your own trustee or remove you as your power of attorney, you still have legal authority to sign your name. You can still sign a marriage license. You can still sign a deed to your house. So if we're really worried about that circumstance, a formal legal guardianship might be established. The family might decide to adjudicate in a guardianship. We try to stay away from that. It's expensive, it's time-consuming, and it's rarely necessary. I mean, I've been practicing 23 years, and I can count on a couple fingers the times that we thought it was necessary. So don't worry too much about it. I just thought I'd mention it. Health surrogates and living wills. Again, you have your loved ones oftentimes named in those documents. And how are those different than your powers of attorney? These are over your health care decisions. Especially if you can't make them for yourself. The living will, you're saying ahead of time what you want done or not done if you're in a terminal condition with no hope of recovery. If you're in that Karen Ann Quinlan or Terry Schiavo sort of situation. Are you all familiar with those names? Yeah, I mean, if we're in that kind of a name, what your living will takes care of and what you've already signed is what you want done and not done if you should ever find yourself in that circumstance. The health proxy doesn't rise to that level. That's the sort of thing like what happened to me when I was on my bike and I was hit by a car and I was unconscious and I'm flown to the hospital and they need some kind of authority by somebody to do some kind of a procedure, right? That's your health proxy. So that's the difference. Now, Mike, the health proxy, are they the ones that also deal with where you go to the assistant? Yeah. The health proxy document also, if you're not already into a life care facility or an assisted living facility or a retirement community like Shell Point or Cypress Cove, your health proxy can also decide to help with those decisions. That bumper sticker that says, be nice to your kids. They're the ones who decide what nursing home you're going to live in. So that's your health proxy, right? So, those, by the way, and we all talk to you about this, but those issues are oftentimes more weighty and emotional, aren't they, than the financial ones. The financial ones are more transactional and, they're more, they're weighty in their own sense. The health ones are more emotional. And oftentimes that's why we hear from you. I want my daughter as my health proxy because she's a nurse and she's a doctor herself and she knows all these things. And I don't want my son, who's the engineer, to be doing this. Right? So that's what that's all about. So in wrapping up, I want to introduce you to somebody. Blake, come on up here. We have a new law associate. His name is Blake Hampton. And he actually, here he is. Everybody say hi to Blake. He was manning the camera back there. Blake, he's not on the mic or on the thing, so I'll speak for you, I guess. Blake is a graduate of guess where? Undergrad? You all know me and Mike, right? University of Florida? Gator. We don't allow anybody in our office other than John Stewart if they're not a Gator. And he's a Stetson University Law School graduate. And he had a concentration of courses in tax and trust and elder law and those sorts of things. He was our runner back in high school, was it?
Since 2003.
Yeah. Blake's been around a long time. He's kind of worked his way up through the ranks. He's been a runner, and he's been a clerk, and he used to man the video, and he did, he's done everything. So I wanted to introduce you all to Blake, and from time to time you may be hearing from Blake too, and we just need more hands because we want to make sure we get your work done for you. So thanks, Blake. So Mike, yeah, we'll open up for questions for a few minutes and let you all go. Any questions for today? Yeah, the question is, I used to have an annuity and I've sold it and now I have a different asset that's in my trust. Yeah, if you open up a new account, the best thing to do is to shoot us a copy of the account. Oh, it's already in an existing account in the trust. That you don't need to worry us about. because we know that the values of your accounts go up and down and so forth and change. We're not too concerned about that really. What we're worried about is, some of y'all chase CD rates around town, and a CD will come due, and then you get a new CD somewhere else, and we don't know about it, and sometimes the bank clerk won't title it in the trust correctly. Those are the sorts of things we want to see when you're opening up new accounts to make sure that they're titled correctly.
One other thing, though, when you do close an account, even if you roll it into an existing trust account, which is fantastic, you might, in your binder that everybody has, there is a trust asset tab. Just put a note in there that says, hey, this annuity no longer exists, because we see a lot after somebody passes away. Well, mom or dad had 5 different insurance policies. These may have lapsed. We don't know if you've surrendered them during life or if they're still in existence. So I see the binder kind of as a one-stop shop for the trustee when they take over, and use that trust assets tab to say, okay, this no longer exists or was sold or converted or whatever it is.
2 questions. First one, I have the original of my trust in my green binder. If it's in my car and somebody steals my car,
Yeah.
and maybe even shoots me or something,
Oh, God.
now what happens in terms of an original trust document?
You want to answer that?
Well, yeah, I mean, we have scans. We've got the electronic version of all of the documents. The 2 that I'm most worried about absolutely having the original one day is the will, the last will and testament. Everybody who has a trust has a pour-over will that basically dumps everything in the estate to the trust. That will have to enter the original one day. And the original power of attorney that we've been talking about, because that's what's going to have to be recorded. If we've got circumstances like yours, and the example was if it's stolen or if something happens, misplaced. If we've got some evidence that says, hey, it was stolen, my car was robbed, my binder was in the car, well, we can have you sign an affidavit, and I'm not too worried about that situation. I'm more worried about the misplaced situation, if we just, which is one of the reasons why a lot of times we'll keep your original will and your original power of attorney in our will safes. But the trust I'm not as worried about, because that's a private document and we can reproduce those.
Following up on that answer for just one, go ahead.
Well, I just created one more question. If I'm incapacitated because at the time of the disappearance of that trust, can somebody else sign that trust document, making an original, I guess it's
The issue, you really don't need the original of the trust, honestly.
Didn't know.
Yeah, so the original of the trust isn't all that important, but what I was going to follow up with on Mike on the power of attorney, one of the reasons we like to keep your original powers of attorney is because, let's say we get the call from your son, who is your power of attorney, dad can't act, mom can't act, what do I do? And we say we have to record certified copies of it. Remember we said that earlier today? If it's in your lockbox, how do we do that? Kind of tough. So usually we ask that we keep the original. You're free to have it if you want it. But if you have it, please keep it somewhere where it is easily and readily accessible. Otherwise, we keep it in our vault. And if it's needed, we just run it down the courthouse and record it and get as many certified copies as we need.
Right.
The other question, if you would.
Yeah.
Are they on the internet also?
Yeah, good question. The question was about the internet and our DVDs. All of our maintenance DVDs are up on the internet. So when you leave, get one of our cards, or our website is if you want to write it down, it's www.s as in Sam, B as in boy, S as in Sam, H as in hotel, law, LAW.com.
If you have really, really, really good eyesight, you can see it at
the magnifying glass.
Yeah, you can see it at the bottom of the handout we gave you on the very first slide.
Right. And if you go to our website, there's a video learning center link. And we have all of our annual maintenance program workshops in one category there. So
My kids could go.
absolutely.
There's a question over here.
The purpose of that little card is
The card you're supposed to keep in your wallets. You have that emergency, the legal directives card?
yes.
Yes, that gives you 24-hour-a-day access to your health surrogate, living will, and HIPAA waivers. So if you are in a hospital, let's say you're visiting your kids up north somewhere, and you have to go to the hospital, and they say, where's your health surrogate? Or they want you to fill out theirs. Don't fill out theirs. Give them that card. They should get access to it, to your health surrogates that you signed in our office.
How do they get access
Because if they have access to the internet or a toll-free telephone number, they can get them because they're uploadable. We may be changing the provider soon on that, so all of you may be getting new cards because we're looking at some changes along those lines. Yes?
I don't remember getting one of those cards. Should everybody have one?
Well, did you look in the inside of your binder, your green binder? It's sometimes in that window, and sometimes we send them to you in the mail. If you're not sure you have the card, just let us know. But like I said, in January we may be issuing new cards anyway, January, February. So, and the date of this video is November of 2012. So any of you watching the video, it's probably January, February 2013. In the back. Okay, the question is, if I have my house in the trust, they charge you more for the insurance policy? You know, yeah.
There could have been some kind of rider that they put on the policy and charge you some jump fee for it.
The question is, should they be able to charge you more if your house is in the trust? What I would say to you, that's a company-wide decision, I guess, but here's what they should know. This is not an irrevocable trust. It's your grantor trust. Your trust is you. It uses your Social Security number. So maybe they're misunderstanding the type of trust that it is. Okay. Well, I guess you're stuck with the $36 unless you go to a different insurance company. I don't know. Yeah. That's a company-by-company decision, is my guess. Right, let's see. Who hasn't asked a question yet? In the back.
Yeah, just for the tape and for everybody, the comment was, after somebody passed away, there are some hoops that we need to jump through. And yeah, we actually have another video on legal matters when a loved one dies. It's on our website, and we've got some outside. But yeah, there are things that need to be done. Now, that's not really the topic of today's workshop. It's while we're incapacitated. But yeah, there are things that need to be done, and it's back to the golden rule, right? The banks make their own rules, and we have to, we've got to abide by the hoops that they want us to jump through. And the comment was, back when we created our trust account, all they needed was the first and the last page. Somebody's passed away. We need to transition it over to the irrevocable trust for the surviving spouse, and they want more information. Well, of course they're gonna want to know more than just those couple pages. But yeah, so call us when that happens, and we'll walk you through the process. That way, it's not a surprise. Yeah,
and by the way, I'll just build on that, and then we'll take one or two more questions, then we'll be done. We'll stick around afterwards. Even though they do require these various things when trust goes from revocable to irrevocable and someone dies, it's still a lot easier than if it had you gone through a probate process, which would have been the alternative. Yeah. So in that situation you have to weigh, okay, what are you weighing it against? Okay, yes sir.
She had all kinds of problems.
Yeah, joint accounts can be very problematic, because there's different types of joint tenancies. There's joint tenancies with rights of survivorship, but there's also tenants in common, which would require the one half of the one who died to go through probate. So, yes, the question was, how important is it when joint accounts, that they're titled correctly? Very important, but we try to minimize those joint accounts, really, in your situations. We like to put things in your trust.
Actually put them in the trust.
Yeah. Okay, want to do one more question, then we'll stick around? Let's go back.
On the what?
On the death of a spouse.
Okay. So after a spouse passes away? Yeah. Like I mentioned, we do have that video.
He's been through the process with
us.
Yeah.
Oh, okay. Come and see us. After a spouse passes away, come and see us, and we'll. Sometimes there's very, very little to do. In a simple joint trust situation, really, it's just a matter of taking the one spouse off. And other times, we've got to create irrevocable trust for the surviving spouse. So each situation is different. It's going to be based on the way the estate plan is. So it's not really the first thing that you have to do, but fairly soon after we lose a loved one, come in and see us and sit down. There are things that we need to do, certain hoops to jump through.
All right. Well, thank you all very, very much for coming. We appreciate your taking the time this morning.
Thank you.
And we'll be around here afterwards for more questions.